Schmerber v. California, Supreme Court, 1966. Justice Brennan delivered the opinion of the court. Petitioner was convicted in Los Angeles Municipal Court of the criminal offense of driving an automobile while under the influence of intoxicating liquor. He had been arrested at a hospital while receiving treatment for injuries suffered in an accident involving the automobile that he had apparently been driving. At the direction of a police officer, a blood sample was then withdrawn from petitioner's body by a physician at the hospital. The chemical analysis of this sample revealed a percent by weight of alcohol in his blood at the time of the offense, which indicated intoxication, and the report of this analysis was admitted into evidence at the trial. Petitioner objected to receipt of this evidence of the analysis on the ground that the blood had been withdrawn despite his refusal, on the advice of his counsel, to consent to the test. He contended that in that circumstance, the withdrawal of the blood and the admission of the analysis into evidence violated his constitutional rights, including his privilege against self-incrimination under the Fifth Amendment. We hold that the privilege protects an accused only from being compelled to testify against himself or otherwise provide the state with evidence of a testimonial or communicative nature, and that the withdrawal of blood and the use of the analysis in question in this case did not involve compulsion to these ends. It could not be denied that in requiring petitioner to submit to the withdrawal and chemical analysis of his blood, the state compelled him to submit to an attempt to discover evidence that might be used to prosecute him for a criminal offense. He submitted only after the police officer rejected his objection and directed the physician to proceed. The officer's direction to the physician to administer the test over petitioner's objection constituted compulsion for the purposes of the privilege. The critical question, then, is whether petitioner was thus compelled to be a witness against himself. In the scope of the privilege coincided with the complex of values it helps to protect, we might be obliged to conclude that the privilege was violated. The withdrawal of blood necessarily involves puncturing the skin for extraction, and the percent by weight of alcohol in that blood, as established by chemical analysis, is evidence of criminal guilt. Compelled submission fails on one view to respect the inviolability of the human personality. Moreover, since it enables the state to rely on evidence forced from the accused, the compulsion violates at least one meaning of the requirement that the state against an accused by its own independent labors. However, the privilege has never been given the full scope which the values it helps to protect suggest. History and a long line of authorities in lower courts have consistently limited its protection to situations in which the state seeks to submerge those values by obtaining the evidence against an accused through the cruel, simple expedient of compelling it from his own mouth. In some, the privilege is fulfilled only when the person is guaranteed the right to remain silent unless he chooses to speak in the unfettered exercise of his own will. Both federal and state courts have usually held that it offers no protection against compulsion to submit to fingerprinting, photographing, or measurements, to write or speak for identification, to appear in court, to stand, to assume a stance, to walk, or to make a particular gesture. The distinction which has emerged, often expressed in different ways, is that the privilege is a bar against compelling communications or testimony, but that compulsion which makes a suspect or accused the source of real or physical evidence does not violate it. Although we agree that this distinction is a helpful framework for analysis, we are not to be understood to agree with past applications in all instances. There will be many cases in which such a distinction is not readily drawn. Some tests seemingly directed to obtain physical evidence, for example, lie detector tests, measuring changes in body function during interrogation, may actually be directed to eliciting responses which are essentially testimonial. To compel a person to submit to testing in which an effort will be made to determine on the basis of physiological responses, whether willed or not, is to evoke the spirit and history of the Fifth Amendment. Such situations call to mind the principle that the protection of the privilege is as broad as the mischief against which it seeks to guard. In the present case, however, no such problem of application is presented. Not even a shadow of testimonial compulsion upon or enforced communication by the accused was involved either in the extraction or in the chemical analysis. Petitioner's testimonial capacities were in no way implicated. Indeed, his participation, except as a donor, was irrelevant to the results of the test, which depend on chemical analysis, and on that alone. Since the blood test evidence, although an incriminating product of compulsion, testimony nor evidence relating to some communicative act or writing by the petitioner, it was not inadmissible on the privilege grounds. The court also rejected other constitutional objections based on the Fourth Amendment, due process, and the right to counsel.